Let's take a look at administrative law. Legislatures create laws, executive officials enforce laws, and judges adjudicate disputes. The Constitution of the United States creates a three-branch system with Congress to create law, the President to enforce laws, and the federal courts to adjudicate disputes. State constitutions establish similar structures for their governments. This is an incomplete picture of government, however. Federal, state, and local administrative agencies have become important vehicles for the implementation of policies, services, and the creation of law, the enforcement of law, and the adjudication of disputes. Indeed, agencies make more laws than Congress, enforce more laws than the President, and adjudicate more cases than the courts, yet they're not mentioned in the U.S. Constitution. The number of agencies in the United States has grown significantly in recent years, as has the authority of these agencies. A body of law has developed to control and regulate their behavior and function. This is known as administrative law. Administrative law defines the powers, limitations, and procedures of administrative agencies. The Constitution of the United States and the states are a significant source of law in the administrative context. The principles of separation of power and federalism embodied in the Constitution are important to the structuring of agencies and, to some extent, in limiting the authority of agencies. Article 1 of the Constitution establishes many of the powers of the national government, specifically the power of Congress to regulate interstate commerce and other matters. The concepts of due process of law and equal protection of laws found in the 5th and 14th Amendments are vital limitations on the power of agencies. A statute that establishes an agency and sets forth the responsibility and authority of that agency is an enabling statute. Congress enacts enabling laws at the federal level, and state legislatures do so at the state level. It's common for Congress to create an agency in one year and to make adjustments to the agency's authorities and responsibilities in later years. Concern about the growing power of the administrative state led to the enactment of the Administrative Procedures Act known as the APA in 1946. The APA is the basic law governing the procedures that agencies must use in the performance of their function. Although comprehensive in coverage, the APA is not the first law of agency governance. The primary law is always an agency's enabling legislation. Often enabling statutes contain different or more detailed provisions than the APA. The enabling legislation is controlling in such cases, assuming constitutionality. The federal APA applies only to federal agencies. Although not a lawmaker, this is an authority delegated to Congress, the President and his or her executive counterparts in the states may issue executive orders. A lawfully issued executive order has the effect of a statute. Executive orders have two sources of authority. The first is Article 2 of the Constitution, which establishes the presidency. Although its framing of the presidency is broad with a few specific delegations of authority, it's generally recognized that presidents possess considerable authority that is inherent to the broad delegations that exist. The exercise of these authorities often involves making decisions of broad application that look and smell like law. Administrative agencies come in many forms and sizes. This is due in large part to the fact that agencies are created to confront an array of problems. In addition, agencies exist at all levels of government. The primary focus of this course is federal administrative agencies, although many of the principles discussed herein apply to all agencies. Administrative agencies have many names, including departments, commissions, bureaus, councils, groups, services, divisions, and agencies. Agencies also have subunits bearing these names. Not all governmental entities are agencies. Courts and legislatures are not agencies. They're constitutionally created branches of government. Therefore, administrative law principles do not usually apply to those bodies. Not all agencies are of great concern to the study of administrative law. The study of administrative law focuses on agencies whose actions affect the rights of individuals, also known as civil rights. In the United States, government operations are split among three branches: legislative, executive, and judicial. There's no constitutional provision establishing administrative agencies. Agencies are created by one of the three branches of government, usually Congress. After creation, most administrative agencies fall under the aegis of the executive branch. Some scholars have referred to administrative agencies as a fourth branch of government. Agencies do not actually constitute a constitutional fourth branch of government. The Constitution establishes only three branches, and agencies are accountable to these branches. Nearly all administrative agencies can be characterized as social welfare, regulatory, or public service. Social welfare agencies are responsible for promoting the general welfare of the people. This mission often includes providing services or cash distributions to persons who qualify for assistance. Regulatory agencies are responsible for prescribing or requiring certain behavior, determining compliance with the law, and prosecuting and occasionally punishing those who violate it. Regulatory agencies possess a wide range of authority. Most control licensing. Regulatory agencies also set rates for certain industries. The third type of agency is a public service agency, which is not involved with the redistribution of money, nor does it regulate. An agency may also be characterized as either an executive agency or an independent agency. Executive agencies are origins of the executive branch. Other agencies are referred to as independent because the president exerts less control over them. These agencies are often headed up by a group of individuals and usually are referred to as a board or commission. Administrative agencies have existed since the birth of our nation. The Departments of War, Foreign Affairs, Treasury, Post Office, and Patents were established by the first Congress. These agencies provided needed services such as mail delivery and protection from foreign enemies. Their regulation of Americans was minimal. Later, in 1887, Congress created the Interstate Commerce Commission, the first federal agency with authority to regulate people and business operations directly. The boom era for federal administrative agencies was during the Great Depression and World War II. President Franklin D. Roosevelt initiated the creation of many new agencies as part of his New Deal efforts to revive the economy and to correct other social problems. Congress supported the president's efforts through legislation creating new agencies and programs such as the Tennessee Valley Authority, Works Progress Administration, Agricultural Adjustment Act, Conservation Corps, and Social Security. The authority and number of administrative agencies continued to expand in the following decades, particularly during the 1970s. Several factors have contributed to growth in government and specifically the growth in the administrative state. First, the increasing interdependence of people is a significant factor. Today, nearly everyone provides highly specialized services. We depend on others for our food, healthcare, technology, and other needs. This change, along with our increasing population, is driving people together, but often in impersonal ways. This interdependence without social connectedness, also known as social distance, not only causes greater conflict, but also leaves society without social infrastructure to informally resolve disputes. The need for more law and government is a consequence. In order for people to be comfortable with their food, medicine, and other products, assurances of safety and quality are needed. A second factor is the growing expectation of the public for its government to regulate in new ways. So-called social engineering is an example. A third factor is the expectation that government will provide more services and benefits than in the early years of the Republic. The framers of the U.S. Constitution did not live in a world where government provided recreation, educational tutoring, unemployment assistance, welfare, Medicare, Medicaid, and Social Security benefits. It was the perceived need for government to address the complex economic ills of the nation, as opposed to trusting the free market to right itself. A fourth factor is increasing mobility of people. Today, domestic and international travel is common. In addition, individuals and families are more likely to relocate for employment, education, retirement, and other opportunity. To illustrate the growth of the federal government, consider the number of people employed by the government. In 1800, 3,000 people were employed by the federal government. There are approximately 5,084,000 people in the United States at this time employed by the federal government. By 1995, the number of employees had increased to nearly 3 million and more than 1% of the total population. The large number of agencies and agency officials is the result and possibly the cause of services and regulation. Consider the extent to which administrative law is present in just a few hours of your morning. You sleep in a bed that was manufactured in accordance with federal guidelines. The bed, like most consumer products, was shipped in interstate commerce. The Federal Department of Transportation, therefore, regulated the shipment. You arise to an alarm that was likely powered by electricity, a product regulated by your local Public Service Commission and, in some cases, provided by your local government. After you leave your bed, you might eat breakfast and dress for work. The Consumer Product Safety Commission, Food and Drug Administration, and Department of Agriculture are ensuring that the clothes you wear and the food you eat are safe. The food you purchase in a grocery store and your local bistro, for example, must comply with local health codes. One study estimated that a hamburger purchased at a local restaurant is governed by more than 41,000 regulations. Freshly showered with water provided by local government, you leave your home, the construction of which has been in compliance with local construction standards and local government permitting, to get to your new automobile. Of course, the design and manufacture of your new SUV was regulated by the federal government. You paid taxes, registered the vehicle, and obtained a driver's license with state and local authority. You drive to work is regulated as well. Your driver's license was issued by a state administrative agencies, and the rules of the road were created by your state legislature, county or city government, or possibly even an agency. At work, you're subject to federal and local laws concerning discrimination in the workplace. Agencies exist to deal with this issue as well, such as the Federal Equal Employment Opportunity Commission. Your safety and that of your coworkers is regulated by the Federal Occupational Safety and Health Administration, as well as by local officials. Under federal law, you're entitled, with certain exceptions, to receive a minimum wage. Other federal laws concern employer-provided health insurance and retirement benefits. You may also have the right to form a union at work. The National Labor Relations Board is charged with enforcing that right. All of this regulation isn't free. Your earnings are taxed. At the federal level, the Internal Revenue Service is responsible for collecting a portion of your earnings. State and local agencies will collect income tax as well. These are only a few examples of how a person's life is regulated by state and federal law. As you can see, the amount of regulation in daily life is high. Little activity today has no connection to the administrative state and therefore administrative law.